My name is John Rudd. I'm a corporate partner at Hutchison. We're a law firm located in Raleigh, and we specialize in representing tech and life science startups. We help a lot of people form their company, and then our goal is to be there as you raise funds, and then if you're successful and you're selling the company, we can help you do that too. So we work with a lot of startups, and if we sort of are. That's all that we do, and so our legal advice is really tailored to startups and not just sort of any kind of business. And so I think you can get really practical advice, and that's something that we really pride ourselves on. Today, my presentation is just on a couple of legal issues that often come up for early stage tech and life science startups. Some of them may be relevant to you, some of them may not, but I hope that at least, one of these topics is relevant for every person here. We'll start out. This is a question I get asked a lot. I'm thinking about forming a company. Should it be a C corp? Should it be an S corp? Should it be an LLC? I don't get should it be a partnership, but that's also one of the possibilities. And people seem to really focus on this point. I think it's like really important. And while it is important, it's something that can easily be changed. And so we help a lot of people move from an LLC to a C corp, sometimes the other way back. But really the way I think about this is, if you are expecting outside investment from professional investors, they're probably going to require that you're a Delaware C corp. And so because that's going to be a requirement, you might as well start there. Now, that's not necessarily that's not where you have to start, right? There's lots of people that come to us and say, hey, I formed an LLC. I've heard you give this presentation, and you say I need to be a C corp. Do I need to change it? And the answer is, I mean, you probably will have to, but there's no reason to do it, now. That we oftentimes, when there's the big first institutional money that comes in, will convert from an LLC to a C corp, and then immediately after that, the investment will close. So it's definitely something that you can do. And if you've already kind of got the company set up, I oftentimes say, hey, let's just wait until there is that investor, who says that you need to be a Delaware C corp. So I think. One of the other, I get this question about like, okay, so why shouldn't I be an S corp, or why shouldn't I be an LLC or things like that? And S corps are, honestly, if you go to your accountant and you say, hey, what kind of in entity should I be? I found that accountants love S corps. I don't really know why, because I'm not an accountant, but I think it has something to do with you can get a little bit better tax treatment than an LLC. And so there is, some advantage there if you have a business that is generating a gain. But from a legal perspective, there are a lot of downsides to S corp, specifically if you're a company that's going to be raising money from outside investors. Even to be an S corp, you can only have 75 stockholders. Now, I normally say, don't have a cap table with 75 stockholders on it, because it just makes everything really, really hard. And you have a lot of people that whenever you need to do anything that requires a stockholder vote, you have to go out and get them to vote, and it can just become administratively expensive. The other thing is you have a lot of people that are calling you up and asking when they're going to get their money back, and then those kinds of things. So that's not a kind of big one, but the second one is sort of you can only have an individual or an estate as a stockholder of an S corp, which means if it means that you cannot have a fund that invests in you because that will be either an LLC or a partnership. And so, that's one of the reasons that S corps normally don't work if you have outside investment. Um, the third one is not always important, but we do have some people that do raise money from outside the United States, and that really doesn't work for an S corp because no stockholder can be a non-resident alien. And then finally, this fourth one is actually also a pretty big impediment, and that is you can only have one class of stock. So really, you can only have common stock, and institutional investors almost always want preferred stock, and so an S corp just doesn't work. Um, an LLC is not always, this is something that does sometimes work, and there are some cases where it does make sense. The real advantage of an LLC is it's a really flexible in entity, so you can do all kinds of things that you just can't do if it's a C corp, because you can allocate uh, profit and loss and depreciation and all the kind of other tax attributes. You can allocate those however you decide to under the operating agreement. But for most people, you don't need that flexibility. And the flexibility is actually kind of a downside because it means that everything, instead of having like a C corp where you have a single set of rules that everybody has to follow, with the flexibility comes a requirement to have a lot more complicated governing documents. And so because of that, these are a lot harder. Like there's a lot more of a chance for you to make a mistake if you don't engage an outside legal counsel at kind of every time you undertake a corporate action. So, this is, again, there are cases where these really make sense. Most of the time, they sort of a company who's not generating a lot of cash, and the cash that they are is being poured back into the business. That doesn't really normally make sense for an LLC. The other thing that's really hard, or at least a lot harder in an LLC, is granting incentive equity can be harder. You certainly can do it, but it's just a more complicated process. And a lot of startups like to use incentive equity as a way to pay a little less cash to consultants, advisors, employees. And so because that incentive equity is such an important tool, it is something that we need to think about. So that's enough about, should I be a corporation or an LLC? The next thing I wanted to talk about, and this is actually a little bit of why you should be a corporation, is there's this thing called founder shares. And one of the other questions I get is, do I have founder shares? What are founder shares? And, this is not like a legally defined term. This is just something that people use as a kind of shorthand. And they use it for, the stock that you receive when the company is formed. And that stock has some special characteristics to it, right? Most of the time it's your getting it for a tenth of a cent or a hundredth of a cent per share, so you're getting it for a very cheap price. The sort of other thing that's pretty important or pretty special about it is it's usually, and this is again only if you're a C corp, it is qualified small business stock. And qualified small business stock is a tax treatment, and that means that you do not pay any federal income tax on the first $15 million of gain. And so, that applies not only to you, but early investors will also get that treatment, and they actually get it, up to 10x their investment amount. So it's something that investors really care about. That's one of the reasons they want you to be a C corp. If you're an LLC, you just don't get this tax treatment. And so it's something I always bring up because it can be a really valuable tool when you do sell the company. I will say a really important thing about founder shares is you want to make sure that the issuance of the shares is actually documented. There's, I know when you're first starting the company, cash is tight, you're deciding, what things do I really need to pay for and what things can I really do myself. You just want to make sure that there is a documentation that the shares have actually been approved by the board and that they've been issued to the founders. I run into this situation, all too often where somebody has incorporated the company themselves. They're a sort of sole founder. A few months later, they kind of find somebody else who wants to be that co-founder role. They all talk about, all right, you are going to get 30% of the company. They never bother to go through the formal steps to document that. And then when they come to me, it's often, we're raising money from an investor. Sometimes it's even we've, managed to bootstrap this and we're going to sell it. You can't just give people stock for free. And so you have both a tax problem and sort of the issuance of the stock. There are ways to issue someone, you would be able to issue them options on a tax-free basis, but it's really it's not going to be as good for them to have options as it would have been to document the stock. The other thing is, you aren't starting the clock for capital gains treatment until you actually issue the stock. So, we do have it sometimes where someone's selling the company. They have someone they considered their co-founder. They never bothered to actually issue them stock. They want them to get, part of the proceeds of that company sale. We can do that. There's lots of ways to do that, but there's no way to get you capital gains treatment on that you're going to end up paying your regular ordinary income rates, which is a whole lot worse than the sort of 0% tax rate that you probably would have paid if you had gotten qualified small business stock. The other really important point about founder shares is you want to make sure that they're subject to vesting. And that's really just so you can be sure that everybody's pulling together in the same direction, where most of the time we say, look, just have time-based vesting, vests over 4 years with a 1-year cliff, which means nothing vests until the end of the first year. That protects you against the problem of, everyone's really excited. The company has started. There's, 3 of you that get together and, 6 or 7 months later, one of the people finds what they think is a better opportunity and walks away. And, if you don't have vesting then the person walks away with all the shares that they got at the founding, which is, normally a significant percentage. And, they walk away with the stock, and everyone else is left there doing all the work. And the person, who didn't have vesting on their stock and quit, they're sort of getting to free ride on that. So, vesting is an important point just from a fairness concern. The other thing is, if you're, 3 co-founders and someone leaves, chances are they had pretty important expertise. You're going to have to get that expertise from somewhere else. You're probably going to have to hire somebody else. They're probably going to want a large amount of stock as part of their compensation. And so it's really nice to essentially be able to, take the unvested shares back, earmark those to be issued to someone else who's going to take that, departing founder's place. And that way, you sort of have that stock and everyone's not taking a lot of dilution to bring that new person on. Like I said, we normally recommend time-based vesting. The kind of default rule is 4 years and a 1-year cliff, right? But there are many different ways that you can do it. And one of the other ways is milestone-based vesting. This can work, it normally does not work for founder shares, because if you knew where the business was going to be in 3 to 4 years, then you're sort of then you have a crystal ball that nobody else has. So sort of trying to pick, okay, what's the milestone that we should hit in the next 3 years? chances are you're coming back to change those milestones. Now, where milestones can work is if you have maybe a consultant or an outside advisor, and that person's supposed to be helping you with something really specific. And in that case, you can sort of, as long as it's a shorter term goal, you can say, hey, I'm going to give you some stock. We've got this kind of, short term, maybe 12 or 18 months, and the stock will vest when we actually achieve that target. That's the kind of one case where I've seen that work, because everybody generally has a pretty good idea as to, how and when that stock should vest. So we've been talking a lot about founders, shares. The other kind of equity that we normally see, outside of the equity that you issue to an investor, is incentive equity. And so this is equity. It could be an option, it could be stock, it could be an RSU, but it's issued to employees and consultants. And it has to be issued under an equity plan approved by the board. And that's just from a securities law compliance perspective. So the way this works is the board decides, hey, I'm going to set aside a certain percentage of the company for issuance under this plan. Anything, 10% is probably the rule of thumb, but that's not a hard and fast rule. You just want to make sure that you've got enough in that plan to kind of handle your short-term needs. And so the board approves it. The stockholders also need to approve it for tax compliance. And then you kind of just have that pool set aside. You normally put it on your cap table so everybody kind of sees their percentage ownership of the company, assuming that full pool is actually issued. And then you can use it to issue stock to employees and consultants. Now, the main types that you can issue are options. I would say that's the most common type. You can issue restricted stock, which is really just stock that's subject to vesting, or you can issue RSUs, which this is something that doesn't normally make sense for a private company, but in the public company context, this is actually you're issuing someone stock for free, and they can sell the stock to pay the taxes. It makes a lot of sense if there's, if you're a public company, but it doesn't make sense normally for a private one. But options, options, I would say, are the default. Sort of, if you're thinking about incentive equity, you're probably thinking about issuing options. The options, they're giving someone the right to purchase shares in the future for a fixed price. That fixed price, called the exercise price, that has to be the fair market value of a share of common stock when the option is issued. And the sort of beauty of that is the option has no value when it's issued, because you're just giving someone the right to buy a share of stock at what a share of stock costs. And so from a tax perspective, you don't have to pay any taxes. The employee's not paying taxes on the issuance of that option. And as the company grows, well, then the option does start to gain value, because suddenly, you have the right to purchase a share of stock at what it was worth a year ago, or 2 years ago, or 3 years ago. And so those options, they'll become valuable as the company grows, as the employee or the consultant has helped that company grow. Restricted stock, we do see this issued less frequently, and that's normally, this is a tax-driven question, where it is, so if you just give somebody stock, that counts as ordinary income. They have to pay taxes on that. Yeah. Most of the time, they sort of don't want to pay taxes on private company stock. They may or may not see cash for. So if you're granting this at the early stages, the value of that stock might be so low that it really doesn't matter if somebody has to pay taxes or not. And so we do sometimes see that granted at the early stages. Like the founder shares, incentive equity is normally subject to vesting. Again, the sort of rule of thumb is vest over 4 years with a 1-year cliff. Um, and just like founders equity, you really need to document the issuance of the options when it's approved. Because if you don't do that, if you don't have a formal board approval, then the options aren't actually issued. And you're in that same circumstance that I was talking about before when you're selling the company where, somebody thinks they should be getting, a certain amount of of the proceeds, but it turns out, you never actually issued the option to them. Um, so kind of switching gears entirely, the other thing that's super important that we answer a lot of questions about is IP. Most tech and life science companies, most of the value of the startup is in their IP. Um, I think about IP in kind of three different buckets. One of them is the IP that exists when the company is formed. That IP, right, we cover that, we cover the ownership of that by when the founders form it, we say, in exchange for your stock, you're going to grant all the IP around the business of the company to the company. And then on a go forward basis, we make sure that the company continues to own new IP that's generated by having every founder, every consultant, every employee agree to assign all IP that they develop in performing services to the company the last part, the last kind of IP is kind of third party IP. And this is something that is probably, I see this most of the time again at founding where there's some third party IP that you want to build the company around. A lot of times it's a patent that is owned by a university. Sometimes there's, a large pharmaceutical company that has a product that sort of they just have, don't have a desire to bring forward in the market. But in that one, you would enter into a license agreement for that. There would be all kinds of economic terms. And so we do a lot of these. These are things that investors really care about. They can really sort of the economic terms can go directly to, how attractive of an investment is it for the investor. And so this is again just something to get right, and it's something that can happen at the really early stages. Now, like lots of things, it is possible to fix this. We do sometimes see investors, they're excited about the company, they don't like the terms of the existing license agreement with, the university, and we can go back and attempt to renegotiate those terms. That's not always successful. It's really better to kind of get something right the first time, but it can be fixed. And so this is just my last slide. This is kind of this sort of is something I've been harping on the entire time. It's much easier, and read that is less expensive. I have to spend a lot less time doing it to get it right the first time than to try and clean it up after the fact. This normally pops up when you have an investor who wants to invest, or when you're trying to sell the company where there's lots of other things going on. It's sort of there's sort of always unexpected things that come up, but we really like to minimize those by having done it right the first time. And then just that sort of failure to document options or failure to document founder shares can really result in people losing out on real economic value. And so those are particularly important to make sure that you document. So that's it. I think I may be right at time.